All right, thank you everyone for being here today. I really appreciate you all taking the time on this wonderful Wednesday morning. You can be doing anything else, so thanks for sharing your time with me. We have a lot of ground to cover, so we're going to jump right in. We're talking about guardianship today, and specifically we're talking about Article 81 guardianship. There's a couple different kinds of guardianship in New York State, but we'll talk a little bit about what sets Article 81 guardianship apart from those other ones a little bit later. So today we're going to struggle with sharing the slides. Hang on one second. Sorry about this, everyone. I'm not a big WebEx guy, so just bear with me. Okay.
There you go. I'm here too. I just with the audio. I'm having I turn mine off.
Yeah, no problem. Okay. I have to click to progress slide, not hit enter. So we're learning this morning. We're all learning something. So today we're going to talk about the need for guardianship, right? What we might be able to do in our lives to better plan so that maybe guardianship isn't needed in the future. We're going to talk about the situations that we do find ourselves in where guardianship might be the last resort we have to turn to. We're going to talk about how you become a guardian. It's a whole court process, and there's a lot of different terms associated with that, so we're going to talk about those. Talk about once somebody's appointed as guardian, what their role is, right? What their obligations are to the court, and what their responsibilities are to their person for whom they're guardian. We're going to talk about some resources for family guardians, namely the Family Guardian Support Project, the thing that I work on here at the Center for Other Law and Justice. And then I hope to have plenty of time for questions at the end. So if you have any questions as we go along, please hold on to them. Jumping right in, Article 81 deals with incapacitated people. And the dilemma of incapacitation, we have it nice, prominently displayed here on one of our first slides, is that it can sort of happen to anybody at any time, and when somebody's incapacitated, they can't really make their own decisions anymore, and that leaves a decision-making vacuum in their lives. So when somebody becomes incapacitated, the dilemma is who is going to make those decisions? What happens now? So sort of the best way to discuss, let me move my view of myself over there. The best way to discuss this dilemma is through an example, right? So meet Moira and Rose. They've been domestic partners for 35 years. They co-own a home together, but Rose has a separate savings account and owns separate rental property. And important to note that they don't have any power of attorney or healthcare proxy in place for each other, right? That's a situation that a lot of us find ourselves in. And then we can imagine something happens. Let's say there's a car accident. Unfortunately, Rose is seriously injured, right, causing a trip to the hospital and a hospitalization thereafter. So the unexpected has happened. Unexpected is up there in quotation marks because it is unexpected, right? We never think it's going to happen to us, but this kind of thing happens to a lot of people every day. So it's not entirely unexpected, right? And so because we can sort of foresee it happening, we should start to plan for some things and be aware of some things that we can do to set ourselves up and our families up for the best road going forward from a situation like this. But right now, Rose is in the hospital, and Moira doesn't have any legal authority to help Rose with the things that she might need help with right now, right? She's in the hospital. She might be fully incapacitated. She might have suffered a traumatic brain injury. She can't pay her own bills, and those things are stacking up. She can't manage her rental property. She can't access that savings account. And without a power of attorney and without a guardianship, Moira can't help her with those things. There's a decision-making vacuum here. So the unexpected has happened. So let's talk about a couple things that we should all think about getting in place as soon as possible because it's important, right? So we should all think about having a power of attorney. And a power of attorney is a legal relationship in which a principal designates an agent to help them manage their property. That is everything to do with what you might think of as property, real and personal. So it's all your money, all your things, and all your real property, your land, your houses. And a power of attorney agent can help a power of attorney principal with those things. Now, as long as the power of attorney principal can still make their own decisions, they're going to keep doing that. They might ask their agent to do something, you know, according to their direction, but the agent is always supposed to be acting according to the direction of the principal in this relationship, up and until perhaps the principal becomes incapacitated, like Rose in our example has become incapacitated. Then the agent, if there's a durable power of attorney, can act, you know, according to what would be best for Rose, what would be best for the principal, and they have that authority to help the power of attorney principal with those things. The important thing to note here is that a power of attorney in a healthcare proxy, which we're going to talk about next, requires capacity during execution, and that is somebody has to know what a power of attorney is, right? What they're designated somebody else to do, what powers they're giving them, and they have to be able to understand that. So in some situations, like in our example with Rose, it would be too late for her most likely to designate a power of attorney, so she's kind of stuck. And then the next thing that we should all think about getting in place as soon as possible is a healthcare proxy. This is a very similar relationship. A healthcare principal appoints a healthcare agent to make healthcare decisions, but this is more for when the healthcare principal can no longer make those decisions for themselves, right? You can imagine a situation where somebody is somebody else's power of attorney agent, and the person, the principal, is out of the country and they need money wired to them, and the agent can go and do that. Healthcare proxy is a little bit different in that the healthcare proxy is never really going to do anything until the principal is incapacitated or otherwise can't make their own medical decisions. So a healthcare proxy is usually a lot shorter of a document because it doesn't have all those specifically enumerated powers that a power of attorney does, right? A power of attorney has, this person can help me with this kind of transaction and this kind of transaction, and they can't help me with this kind of transaction, this kind of transaction. Healthcare proxy is a lot shorter of a document. It says, this is the person I want to make decisions in case I cannot make them for myself. But a healthcare proxy can also contemplate specific situations, right? Should I become incapacitated and I need to be sustained by artificial hydration and nutrition, I don't want that. You know, you can discuss in that document some situations in which, you know, you might have some specific wishes. If there are no specific wishes, you know, hopefully the healthcare proxy agent has had conversations with the healthcare proxy principal to understand their beliefs and wants about what they would want in different situations so that they can make the best decision for them in accordance with what they would have wanted. Again, this requires capacity during execution. So again, unfortunately, in Rose's example, it would be too late for Rose to designate Moira as her healthcare proxy. But here in New York State, we do have the Family Healthcare Decisions Act. There is a default decision maker in case there's not a healthcare proxy, not a guardian. It's different, again, from a power of attorney. There's no default decision maker. There's nothing to back up, you know, if somebody's stuck in a hospital and they can't manage their own property, their property's stuck unless a guardian's appointed. At least with healthcare decisions, we have the Family Healthcare Decisions Act, and we're going to talk about that right now. This is something that the state put in place to avoid the situation where somebody ended up in a hospital and there's no legal authority by anybody to make a medical decision, but something needs to be done, right? It was a very uncomfortable situation for family and for doctors, and would, you know, typically result in consulting ethics boards and what do we do in this sort of situation? So this is the remedy to that there should always be somebody that can make those decisions if there's not a healthcare proxy and if there's not a guardian. So that it provides a hierarchy, a list of people who will make that decision if there's nobody else to make that decision and if the person is incapacitated, right? First, it's a legal guardian. If there's a guardian, it should be them. If there's no legal guardian, then the spouse or domestic partner. If there's none of that, then an adult child, so on and so forth. So we can all think about our family trees, and maybe the closest person I have on this list is my brother, but I have a friend who's closer to me who knows my wishes a bit better. That would be an important reason to still get a healthcare proxy in place. Even though we do have this, and this is a very good thing to have in New York State, maybe not everybody would want the person who the responsibility would fall to under this act to have that authority. Maybe there's somebody else they would want to designate. So we should all think about getting our healthcare proxies in place. And then we're going to touch just a little bit on supported decision making. This is really how we all make decisions in our life, right? We don't, most of us aren't so rash that we don't think about anything and don't ask anybody their opinion on the things going on in our lives, but we talk to folks, we get their advice, we weigh the pros and cons, and we try to come to an informed decision. And this is here, for certain situations in which maybe, somebody is incapacitated, they can't do a healthcare proxy, they can't do a power of attorney, but maybe they're still functioning at an all right level that they can make their own decisions, so far as, maybe they need some help with those decisions, right? And if they have a close family or close friends, they should really think about supported decision making. This is something that should be thought about. Is there a situation that's workable so that we can avoid guardianship? Because guardianship, as we're going to talk about, is the last resort. It's a very, in a lot of ways, it's a very severe remedy that we should try to do everything short of before exploring. So the unexpected, but not the totally unexpected, has happened. And what do? There's no power of attorney, there's no healthcare proxy. Supported decision making doesn't seem like it's going to be a possibility here because Rose is totally incapacitated. What is the answer? Well, the answer probably is Article 81 guardianship, at least here in New York State. That's the part of the law that it's under. And so we'll talk about the basics, and there's nothing more basic than what is guardianship. Well, it's a legal process designed to appoint a trusted third party to manage the affairs for a person in need of assistance. And so it's about getting a decision maker in place for someone who needs help because they can't make their own decisions. In New York, there's 3 different kinds of guardianships, right? There's the one that we might think of off the top of our heads, like for, orphan children. That's taken care of under Article 17 of the Surrogates Court Procedure Act, right? If there are no parents, there needs to be a guardian for children. And the next one is guardianship of persons with developmental disabilities. This is handled under Article 17A of the Surrogates Court Procedure Act. And that is a very important type of guardianship, because you can imagine a situation in which there's a person with a developmental disability, usually a kid, and their parents or their loved ones are helping them make all the decisions and helping them through life during the first 17 years and 365 days of their life, or 364, however you do math. But then they turn 18, and technically that legal authority for their parents to help them make those kinds of decisions, make the doctor's appointments, all that stuff evaporates. Article 17A is the answer in a lot of those situations to continue that kind of relationship where a parent or loved one is usually the Article 17A guardian of a person with a developmental disability. But what we're here to talk about today is guardianship of adults who consent or are deemed incapacitated under Article 81 of the Mental Hygiene Law. And unlike the other ones, this kind of guardianship is geared towards people who once had capacity and now have lost it, right? The usual situations for lost capacity are a traumatic brain injury, like happened to Rose in our example, or as we get older, a lot of us unfortunately develop cognitive conditions like dementia or Alzheimer's, and those things can progress to the point where we are incapacitated. So what is it? Red circle. That's the one we're talking about today. And so what is the legal standard for incapacitation? A person is deemed incapacitated if they're likely to suffer harm because, 1, the person is unable to provide for personal needs and or property management, and 2, the person cannot adequately understand and appreciate the nature and consequences of such an ability. So it's a little legalese. It's not as legalese as a lot of the law can get, but what it really boils down to is somebody can't take care of themselves and they don't understand that they can't take care of themselves, so that they're likely to suffer harm. It's sort of a 2.5 prong test, if you will. So that's the legal standard. And Article 81 guardianship, again, is different than just going to get a power of attorney and a healthcare proxy. Those things are legal arrangements that you can take care of with an attorney and with your agent in the span of an afternoon, maybe, or a couple of days, right? It's in relation to an Article 81 guardianship, it's a much simpler and cost-effective process to get those things set up. Article 81 guardianship necessarily involves the court, because if a guardian is appointed, that has severe implications for the civil liberties of the person under guardianship, right? If a guardian is appointed, they're not going to be able to make their own decisions anymore. The guardian will. So how does that process play out? Well, a guardianship is begun by a petition being filed, and that petition alleges that somebody, in the process they're called the alleged incapacitated person, that the alleged incapacitated person cannot take care of themselves, and they don't understand that they can't take care of themselves, and they would benefit by having a guardian appointed for them. Important to note about the petition is that anybody can file a petition on behalf of anybody else. Again, let's return to our Moira and Rose example. A lot of times it'll be a loved one who files a petition, and in those situations, right, the petitioner may want to be the guardian at the end of the day. But there is no need that the petitioner be the guardian at the end of the day. And in fact, sometimes the petitioner cannot be the guardian at the end of the day. Let's tweak our hypothetical just a little bit and say Rose is single, she suffered this car accident and this traumatic brain injury, and unfortunately she doesn't have any family around either. She's really sort of on her own. Well, then in that sort of situation, if she can't make her own decisions about the medical care that she needs, about being discharged to rehab or a facility, the hospital in that sort of situation may bring the petition to get a decision maker in place. And so that's just, the hospital cannot be the guardian at the end of the day. They don't want to be and they cannot be. That would be a conflict. So that's a lot of the posture that these cases get started in, right? It's a hospital or facility that needs a decision maker in place who files a petition, or it's a loving family member who does maybe want to be the guardian at the end of the day, and they need to get somebody, they need to get that authority to help their person. So once the petition is filed, the court will appoint a court evaluator. And the court evaluator's job is to be the eyes and ears of the court, like in that cute little graphic. They're conducting an investigation. That means that they're going to ultimately make a recommendation as to whether or not this person does or does not need a guardian. And they do that by interviewing the person. They will meet with the alleged incapacitated person, ask them a series of orientation questions, and try to get, their own independent evaluation of whether or not this person might or might not need a guardian. They'll call and interview family if there's any available and that they can get in touch with, and the court evaluator can get a further court order to get medical financial records so they can have as complete a picture as possible when making a recommendation to the court as to whether or not this person needs a guardian or does not need a guardian. So they're doing the investigation, and their job is sort of threefold. Primarily, they're doing the investigation and ultimately making a recommendation. They're also, when they interview the alleged incapacitated person, they want to see if the person objects to the guardianship or if they consent to the guardianship. In some situations, an alleged incapacitated person will consent to a loving granddaughter being their guardian because they know them, they trust them. Maybe they have some insight into the fact that they don't have insight. Maybe it's a situation in which they have dementia and they understand that it's a progressive disease and that they're going to need some help, so they might consent to the guardianship. But in a lot of cases, people object, right? Even if it's clear to everybody else in the world that somebody could use some help, people are very stubborn, and some of the things that lead to a guardianship being needed, traumatic brain injury or cognitive decline, lead people to be even more stubborn. So they won't recognize that they need this kind of assistance. And people are, inherently individualistic. They think they can handle everything themselves. So if they object to the guardianship, because there is so much at stake for them, they have the right to an attorney to represent them and fight the guardianship. Say that whatever they have going on now is just fine and they can take care of themselves, or there's some other alternative that's possible that is short of guardianship, so that the guardianship should not be appointed. And then the third small part of the court evaluator's role is to figure out if a guardian needs to be appointed, who ought that guardian be. And they'll ask family members, and if the statute prefers that family be guardian, so they'll definitely check with all the family first and see if somebody wants to step up and be the guardian, because they'll ultimately recommend, if a guardian needs to be appointed, that that person be appointed as guardian. So that's the whole court process, right? Petition, investigation. There's going to be court appearances and hearings. That process can be longer if there is an attorney for the AIP, right? There might be more return appearances, more hearings to really, have that fight go on about whether or not the guardianship needs to be put in place. But this isn't one of those court processes that drags on forever, right? We hear about lawsuits, we hear about criminal cases that, those things are in the courts for years, sometimes decades. It's really remarkable. This isn't one of those. Even if there's a lot of court appearances and hearings and fighting about whether or not a guardian needs to be put in place, these things are often necessitated by some sort of crisis where a decision maker needs to be put in place. So these things usually are a few months long, right? It doesn't stretch, much longer than that. So, but that process can be made shorter if the person consents, right? If a person consents, there won't be an attorney for them, and that can make the process go even faster and be less costly to all involved. So, for the purpose of our conversation today, though, let's say that a guardian does need to be appointed, that Moira is appointed as guardian of Rose. There's a lot of responsibilities that a guardian steps into. To be someone's guardian is really to step into their shoes, legally speaking. They'll be making financial and medical decisions. They've got to keep good records as a good fiduciary. And then they're going to have homework as a court-appointed family guardian, court-appointed Article 81 guardian, I should say. They're going to have to report to somebody who we'll talk about in a few minutes about what they're doing as guardian and how it's going. So, all of that said, what kind of guardianships can you have from an Article 81 guardianship? Well, you can be somebody's guardian of their person, which is very much like being a healthcare proxy, right? You're making the personal decisions relating to healthcare and other aspects of life. And you can be somebody's guardian of property, which is very much like a power of attorney. You're managing their finances, real property, and personal property. Most times, if a person needs help with their property, they probably need help with their person, and vice versa, right? So even though you can just be somebody's guardian of the person, or just be the guardian of the property, in a lot of situations, one person does become the guardian of the person and property. There are different situations and circumstances which could lead to there being co-guardians, and there two or more people, but usually two, are guardian of the person and guardian of the property, and there can even be bifurcated guardianships where excuse me, I lost my train of thought. There can be bifurcated guardianships where one person is the guardian of the person and one person is guardian of the property, right? That might be called for in sort of a situation where there's really complex things going on with the money. There's lots of properties and lots of different accounts, so maybe there needs to be a professional guardian of property, somebody who sort of does that for a living. But there's a family member who wants to be guardian of the person. Those sorts of arrangements are possible. It's up to the court to decide which type of guardianship is necessary and who ought to be each guardian. So And then two more things I wanted to note on this slide is that when you're somebody's guardian of their person and when you're somebody's guardian of their property, like I said, it's very much like being their power of attorney and healthcare proxy, except that you have more power as a guardian. As a guardian of someone's person and property, you can choose where they live. It's in the legalese, it's choose the place of abode. And that's, of course, easier said than done, but that does give you the authority to say if your person's in a hospital when you become guardian, you can sign the discharge paperwork. You can sign the admission agreement to a facility or the rent agreement in an apartment, right? You get to choose where they live in that matter. Now, you don't get to, if somebody is in an apartment and they need the time has come for them to be in a facility, right, of some sort because they can't take care of themselves at home and in-home care isn't working out, you can't exactly chain someone to the taxi as guardian, right? That is not under your power as guardianship. So again, it's easier said than done, but it is technically a power a guardian has on paper. The other easier said than done power that a guardian enjoys is to choose someone's social environment. And that means that they can choose who visits their person under guardianship and who their person under guardianship can visit. Again, I've said it a few times now, but easier said than done. If your person's in a facility, right, and there's a problem family member, you can communicate to the facility that, this person should be screened. You don't want them seeing the person under guardianship. It's bad for them. But making sure, that's communicated across all shifts at all times is more difficult to affect in the actual real world. So just wanted to highlight those two big powers that a guardian enjoys more than a healthcare proxy, more than a power of attorney. If I was my brother's power of attorney, I could not tell him where to live. If I was his guardian, I could try. So you're appointed and you're guardian of the person and property. What's next? So let's overview some of the initial steps that a guardian must take upon appointment. First things first, this was a court process. It's going to result in a court order signed by the judge who is overseeing the case that says, the court order will say, this person has consented or this person has been found incapacitated and you, or whoever, has been appointed as guardian. And the guardian has these specifically enumerated powers. We're going to talk about it a little bit later, but guardianship constantly struggles with itself to be less restrictive on the people under guardianship. So the court order, one way to be least restrictive is that the court order specifically enumerates what powers the guardian has. So once you get your court order, you should review that. That's going to be your guiding light in everything you do as guardian. Then you got to take care of your oath and designation. Your oath is, you are who you say you are, and you swear you're going to do a good job as guardian or try your best. Designation is a statutory requirement that you have to designate someone with the county clerk to receive process in case you're sued while out of state as guardian. Sued while out of state as guardian. You mean I'm going to get sued when I'm guardian? No, not exactly. It's really, really rare. Not a lot of lawsuits fly around the guardianship world, but it is a statutory requirement just in case. And then you got to get your commission from the county clerk, and that is a restatement of all the specifically enumerated powers that were provided to you in the court order, and the county clerk says you're commissioned to act on these powers. The commission is supposed to be the document that a guardian walks through the world with, gives to the bank, gives to the nursing home, gives to the pensioner to prove that they have the authority to do these transactions, to work as the guardian of the person under guardianship. But in the real world, a lot of people just want the court order. They want the thing with the judge's signature on it. So I tell all my folks I work with on the Family Guardian Support Project to bring both documents whenever they're doing business on behalf of their person. You're never sure what you're going to get asked for. And then all guardians must do video training provided by the Guardian Assistance Network. That is, it's mandatory. I've never seen it waived for new guardians. That looks like this. The Guardian Assistance Network has 3 videos. They're around 40 minutes each, so they total about 2 hours. And you have to watch them to get a little bit of a to get your feet wet in what you're going to be doing as guardian. A lot of it focuses on being a good fiduciary and managing the money, because that's a very important part of guardianship. But you know, you have to watch these videos as a new guardian, and you have to get your certificate of completion for watching them. When you're watching them, there'll be periodic codes. You know, we've all done our, you know, insurance, our car insurance courses, right? And we got to send that off to make sure we get our 15% discount or what have you. It's the same sort of deal. You got to send off an affirmation viewing to prove that you actually watch the videos, and the Guardian Assistance Network will send you back your certificate of completion. These videos are public facing. They're available online at any time for anybody who wants to watch them. It's not like when you become a guardian, you get a special login to this. These are totally available. So if anybody's interested in learning a little bit more in depth about what is expected of a guardian, I think these are a really good resource to look into. So, oath and designation, commission, certificate of completion for the online course. Those things are important to take care of as early as possible, because by the end of your first 90 days, you must submit your initial report. And that is, the initial report is your homework as guardian. That's how I like to explain it to people. It includes a section on the personal information of the person. Okay, this is where they're living. It's a suitable level of care. This is their condition. This is the plan going forward for helping them. That's for the guardian of the person. And then there's a financial section. This is what they have at the beginning of the guardianship. They have this checking account and this pension, and they're getting this much in Social Security, and those things should be being marshaled into a guardianship bank account. That's a big point of the videos as well, to talk about the fiduciary duty to segregate funds and create a guardianship bank account so you can hold the person's monies and help them as guardian. And it's just about, the initial report is just supposed to be a snapshot of your loved one's situation at the beginning of a guardianship. So this is the situation that you came into. And then that is submitted to someone who's called your court examiner, who is really not helpfully named because it's a different person than the court evaluator, who we talked about a few minutes ago, who during the court process was conducting that investigation. They're both CE, and that leads to me saying them wrong all of the time. But your court examiner is an attorney who will be appointed by the appellate division to oversee your case as guardian, and that is who you submit your reports to. You can visit the Guardian Assistance Network, again, like I said, for more information. They've got lots of good resources about what guardianship looks like. Excuse me. And then, you know, that's your homework part of it, right? You're visiting your loved one. You should visit your loved one within, you know, the first 90 days to lay eyes on them, to see that they're okay, to see what you need to do to make sure that they're okay, and start planning for their loved one's care needs, right? If your person's in a facility, is that facility okay? Do you like that facility? Does your person like that facility? Is it a suitable level of care? Maybe that it's an assisted living, but your person needs skilled nursing, right? That's something that you should be exploring in your early days as guardian, to make sure that your person is taken care of. Organize all their papers that you can get your hands on, and ensure that important documents are accessible, right? Find their bank statements, find their birth certificate, find their Social Security card. Make sure you have all that stuff, because you might need it as guardian. And then follow up on any time-sensitive matters, applications for benefits, etc. You know, usually when people have guardians appointed for them, it's because they've been undergoing some sort of crisis, so they might not be on top of everything. And it's part of your job as guardian to get on top of everything. If they're you know, eligible for some benefits that they weren't taking advantage of, well, then you should do that, so that they're is taken care of and have access to everything that they should have access to. So that's what the early days of a guardianship look like, and this is very overwhelming for new guardians. I talk to a lot of new guardians as part of the Family Guardian Support Project here at the Center for Elder Law and Justice, and people really tend to be overwhelmed in this period. But I tell them, you know, it gets easier. It never gets easier, the day-to-day standpoint, right? You always have to be on call for that 2 a.m. phone call that your person has fallen, or there's an issue, or something has happened. But once you get the initial documents squared away, your initial report, you get the guardianship bank account set up, you know where everything is that you need, you become representative payee for Social Security benefits, stuff starts to even out, and then you can focus more on caring for your person. So, those are your first 90 days, to first 100 days or so as guardian. What do you have to do after that? Well, you got to visit your person 4 times per year. That is statutorily required. Now, it doesn't sound like a lot, right? Like, some of us might see that and think, oh, if I'm guardian for my dad, I'll see him all the time. And that is my experience, right? A lot of the family guardians I work with, if it's a wife for a husband or a husband for a wife or a kid for a parent, right, they might go see them every day. So this requirement isn't that difficult for them to meet. But it's something to think about, right? Because we never know where life's going to take us. And, let's say your person's here in Erie County, and then you move to California, right? Well, you still got to visit your person 4 times per year. So just keep that in mind, right? I have a lot of guardians from other states that their person's here, but they live in Texas or Michigan or Pennsylvania, and that requirement can be a little bit more difficult sometimes. And then you get more homework because it never stops. You have to file an annual report every year in May. That's always due on May 31st of each year, and that's for the preceding calendar year, January 1st to December 31st. And it's similar to the initial report in that there's a guardian of the person section in which, okay, what happened with my person during that previous year? They got sick in July and they got this treatment for it, and they had this doctor's appointment and they had this go on and that go on. So, you should be talking about, is the current level of care still suitable? Those kinds of things. And then there's a financial aspect for the guardian of the property, which can be pretty burdensome, right? So it's covering a calendar year, and you have to account for every penny that went into the guardianship account and every penny that went out of the guardianship account, or your control as guardian, right? Maybe there's an account that you've left open because it's getting interest, and as a good fiduciary, you didn't want to close that out because it's earning money. You got to account for everything that's in your control as guardian and what you did with the money, okay? Manage property, arrange for care, right? That's something that we might not think about, right off the bat when we think about guardianship. If our person who we're guardian for has a property, we gotta see that the grass is mowed in the summer and spring so that you're not fined, and then you gotta make sure the sidewalks are shoveled in the winter. There's make sure the pipes don't freeze, that the heat's up. Pay for the gas bill, right? There's managing property. And that can be pretty burdensome as well. And then there's arranging for care. Sorry, my computer's freaking out a little bit. Arranging for care, right? And again, we're talking about, is your person at home? Is there in-home nursing service that you've set up? Is that working out? Do they need a higher level of care? Are they seeing their doctor? Do they need to go to the dentist? Even if a person's in a facility that should be taking care of all of that, maybe sometimes it takes the guardian poking and prodding to make sure that that is taken care of. And then on the annual report, there's a section where you can ask for changes in the guardian's powers. But I tell everyone, if you need a change in your powers, if you find that by the order there's not something you can do that you need to do, well, I would advise people to go back to their attorney who helped them petition, or to hire an attorney if they didn't petition, right, to get an amended order as soon as possible so that they can do what they need to do as soon as possible. Okay. Okay. Guardianship as least restrictive means. We've been sort of talking around this a lot today, right? Guardianship is a very severe remedy. If somebody has a guardian appointed for them, it has the potential to really, somebody else has the decision-making authority for the person under guardianship. That can be a very restrictive scenario. And we've seen that recently, right? With Britney Spears, that saga has been in the news a lot over the past few years, and it's really given everybody a good impression of what can go wrong with a guardianship if it's not properly done, right? And even guardians who think that they have their person's best interests at heart, maybe they're being a bit tyrannical, right? So we're always trying to have things set up in guardianships that inherently make them as least restrictive as possible, and that's to those specifically enumerated powers and and fostering independence in our people under guardianship, right? That's the underlying tension we're talking about is we all have, right now, as long as you're of your full capacity, freedom to make our own choices. I can choose to go get a coffee before work today or make it at home, right? I get to make that own decision for myself. Guardianship, really has the potential to undermine the rights and independence of the person under guardianship. They're really subject to their guardian in a lot of ways. And so that's the tension we're talking a lot about in guardianship, and why it's important to have a healthcare proxy, power of attorney, other arrangements made up so that, we can avoid this completely as much as possible. And in New York State, the law specifically has it in there that the guardian shall afford the incapacitated person the greatest amount of independence and self-determination, and more legalese, really that's possible, that the person can exercise. And sort of how is that done? Well, it's sort of done through incorporating supported decision-making that we talked about earlier, right? Guardians should be mindful of their loved one's self-determination by allowing them to exercise autonomy in their daily life. That is, if somebody wants to wear a sweater and it's the summertime and, it's a pretty breathable sweater, they're not going to hurt themselves, go for it. A guardian doesn't need to micromanage the person's life like that, right? And those decisions can be important, for our sense of individuality, for our sense of independence. Participate to the maximum extent of the person's abilities in all decisions that affect them, If, right, like if a person doesn't like the facility that they're at and has a pretty informed, they're living there, has a pretty informed opinion on that, well, maybe the guardian should listen to them and work with them to maybe think about a different facility, how to get transferred, or how to make the situation at the current facility better. Act on their own behalf in all manners in which a person can do so. Just because a person has consented or has is subject to a guardianship because they've been found incapacitated doesn't mean that they can't do anything. We have people who the Center for Elder Law and Justice is guardian for who live in the community, right? They're not all in nursing homes and skilled nursing facilities. They have their own apartments, or they live in group homes, and they hold jobs, right? And they travel by bike or by public, by public metro, and they can do those things, right? And guardianship is not a finding of total ineptitude, right? People can still do a lot of things for themselves, and then develop or regain a sense of independence and fulfillment. That's important, right? In a lot of guardianships, maybe it's for a person who has dementia, and there's unfortunately, that's a progressive thing, and then it doesn't get better, right? But sometimes a guardianship is put in place for somebody who has a mental health issue, and after having a guardianship for a while, they see the right doctors and get the right therapy and get on the right, medicines, such that they can take back over and manage their own lives. The guardian should always be trying to foster that sense of independence as much as possible. So, again, we're trying to find that balance, the self-determination versus what the guardian needs to do to help their person, right? There's a guardianship for a reason. It's not supposed to be totally hands-off, but it's not supposed to be tyrannical. It's not supposed to be a prison sentence either for the person under guardianship. We have to strike a good balance there. So that is a pretty quick crash course in guardianship, sort of how it comes about, what can be done to try to avoid it, what the role is and the obligations and responsibilities are of a guardian if one is appointed. So I'm just going to spend a couple more minutes and talk to you just a little bit about some resources, right? I work here at the Center for Elder Law and Justice on the Family Guardian Support Project, and that's a program that we run with the generous support of the Ralph C. Wilson Jr. Foundation, Go Bills, and Foundation 214. What do we do? What do I do? Well, I consult with acting court-appointed family guardians. I explain reporting requirements. I deliver expert technical assistance on individual cases, and I provide ongoing support for family guardians. A lot of the cases that I get come down to sort of two categories. In most situations, I either have a new guardian who's totally new to all of this. They need to get their oath and designation. They need to get their commission. They need help getting their initial report done properly, and we help get them off on the right foot, right? And then I have folks who, especially in light of the pandemic, right, have fallen behind in their annual reports. They're a good guardian, maybe they're even the primary caregiver for their person, but they're just a little bit behind on their homework. And who hasn't been there, especially with everything that's gone on the past few years? So we help those people dig out and get their annual reports all caught up so that they don't face removal as guardian. And then, so that's a lot of my job, is helping with the initial annual reports, but I really try to give my best advice on anything a guardian might be dealing with as guardian, right? Okay, the bank isn't cooperating with me to marshal the assets. All right, let's look at the order. Let's highlight the clause in there that gives you the power to marshal the assets, and let's talk to the bank again. Let's see if we can get them to understand that you do have this authority. And sort of anything that a guardian might come into contact with, I do try to give some advice on at least. What don't we do? So we talked about how a guardianship starts, and that's with a petition, and that is not something that the Family Guardian Support Project can do. Part of the eligibility for our program is that you have to be a court-appointed Article 81 guardian. Petitioning is complicated, and it's technically possible to do pro se, that is without the help of an attorney. But given the likelihood that the person subject to the guardianship proceedings will object and get an attorney appointed to them, and given the overall complexity of the process, we really recommend hiring an attorney. And you can contact an attorney, find an attorney to help you with that through your local bar association's referral service. And then, we cannot represent family guardians in court. We do a limited scope representation thing here with the Family Guardian Support Project, so I tell everybody in my first phone call with them, if they want help from the Family Guardian Support Project, I do happen to be an attorney, but I'm not their attorney, right? I can help them with the reports and some of their documents, but if they have to go back to court to get, court approval to sell a property as guardian, if they have to go back to court because they're facing removal because they're not doing what they should be doing, if they have to go back to court to get discharged because their person has passed and they've done their final report and everything and they're ready for the guardianship to wrap up, I can't help with those things. So with that caveat, those are the things we don't do and can't do. Again, eligibility, I touched on this, but you must be a court-appointed family guardian. You must be here in one of the 8 counties of Western New York. And then I need to get some basic demographic information about you and about your person under guardianship so that we can properly track cases in our case tracking software to make sure we don't have any conflicts. So that is something that I do need upon our first talk to be able to help. Additional community resources. If you have a question about something you cannot do, question about guardianship, your court examiner should always be one of your first calls. If you have if there's a interpretation question about something in the order, and you think it means this, you're just going to want to clear that with the court examiner and get their blessing to take whatever action you're thinking about taking. Once you're appointed guardian, you'll get a letter from the appellate division of the 4th Department, and that will let you know who your court examiner is. If your person is suffering from Alzheimer's or dementia or has some other cognitive condition, Alzheimer's Association, they have a lot of support groups and good resources. And then NY Connects for any and all of us to get sort of in touch with resources that might help us in our own specific situations. How to reach us here at the Center for Elder Law and Justice. Phone number and website are there on the screen. 716-853-3087 is the phone number. We have offices in downtown Buffalo, where I sit right now. We have an office in Lockport. We have an office in Dunkirk. But we also definitely pride ourselves on being able to meet people where they're at, right? If you live betwixt and between one of these places, and you need some help, and you call in, we do intake, and we think we can help, well, maybe we can meet at a community center, maybe we can meet at your home to see what we can do to help, right? We really pride ourselves in being able to meet people where they're at and seeking legal advice as convenient as possible. Center for Elder Law and Justice doesn't do a lot of the work that you might think of when you see the words elder law, right? We don't do estates, trusts, not too many wills, stuff like that, because that stuff is capably handled by the private bar. Things you might not think about that we do, we can help with. Let's say you want to get a service covered under Medicaid or Medicare and you've been denied, we might be able to help you with an appeal. Let's say you're an older person facing eviction, we have a housing department that might be able to help with that. So we have a bunch of different departments here. I'm not going to go through all of them right now, but the best thing to do if you think you have a legal issue that we might be able to help with, give us a call, and we'll screen it. We'll see if it fits in any of our programs or departments, and even if it doesn't, we'll try to get you, connected to somebody who can help. And we also have our free senior legal advice helpline. This is for people age 55 and up. This is, maybe you don't have a full-blown legal issue, maybe you just have a legal question, or you have some sort of smaller thing that you're thinking about. This is a good resource for those kinds of things. It's staffed by a live attorney from 9 a.m. to 11 a.m. Every Monday through Friday. If you call during those hours, you'll most likely get a live attorney. And if you call outside of those hours, you can leave a voicemail and you'll get a call back within a couple days. The phone number for that is 1-844-481-0973. And then, again, I just want to thank everybody here so much for attending today. I really appreciate your time and your attention. So thanks so much. And,
Thank you.
If we have some time, I'd like to hear some questions. Okay. Let me stop sharing here. Okay.
Can you hear me okay? Dan?
I can, yes.
I'm still echoing through my computer, so there's a big problem on my ecology. But
No
there are
worries.
some things in the chat. Are you able to see those?
Let me see here. WebEx is. Yes, okay, I found the chat and I found, okay. Okay, I see the chat. I don't see any questions.
Okay.
Hands?
I'll read it to you.
Okay, thank you. I can't hear you. I can't hear you. Now I can.
Okay.
I'm so sorry.
Does 81 guardianship have the final decision on medical issues? I.e., if the person is capable of making decisions, can the guardianship override his decision?
That can get really sticky, right? Technically, if a guardian of the person is appointed, they do have that decision-making authority. But if somebody's in a hospital and they're not willing to go along with what the guardian thinks ought to be done, right, we run into easier said than done again. Technically, the authority lies with the guardian, but it can be very hard to affect in the real world. And if there's something like that, your best, it's not a good option, but your best option is trying to convince the person to go along with the procedure, that it is in their best interest. But sometimes when people don't have that insight, right? And then you have to think about, for a lot of people, especially as they're suffering progressively from dementia or Alzheimer's, one of these things that typically can lead to a guardianship, right? Is it worth it right now for their quality of life, right? Sometimes interventions can lead to more difficulty, even if it would be better in the long run. So those are different things to sort of think about as you're making those decisions. So the short answer is technically yes, the guardian gets the final say, but you can't exactly strap somebody to a gurney and wheel them into surgery. It's not possible.
Okay. Next question is In case of mental illness, which can wax and wane, does the guardianship powers change or go dormant and then go back and forth?
Not they don't go dormant, because, upon a finding of incapacitation or consent, those powers are given to the guardian, right? So they should still be affecting those powers. They should still be sort of in control of everything so that they can make their reports, right? But that runs directly against sort of letting somebody have as much self-autonomy as possible. I have some folks that one person I'm thinking of in particular that I'm helping right now, where she's guardian of her mother, who has has struggled with some mental health issues in her life, but she seems to be getting better. She seems to be really no longer in need of the guardianship anymore. So it's sort of maybe in those situations it's a maybe hands off, but keep an eye on everything. And then once it seems to have stabilized for the better, then you can really explore getting the guardianship lifted. And that if it's a consent guardianship, the person who gave their consent can withdraw the consent. That's the person under guardianship, which sort of triggers the process starting over. Article 81 guardianship in a lot of ways is case specific, right? I don't want to say it's made up as we go along, but how you actually end a guardianship like that, whether it's through resigning or consent being withdrawn, and what that does to the process is something to figure out on a case by case basis. But in a lot of situations where, because that can be, right, people can be suffering from mental health difficulty, and that does wax and wane. Hopefully it stabilizes for the better, and then the guardianship can be entirely dispensed with at that point.
Okay, thank you. Last question we have. Is your guardian help for all ages, not just elders?
Right, the Family Guardian Support Project here that I work on. So if somebody's appointed a family guardian, this person that I'm just thinking about right now, I think she's in her 20s, right? So that is open to guardians of all ages. That is not one of our age gated programs that we have here at the Center for Elder Law and Justice.